Good afternoon, everyone. Welcome to the Joint Standing Committee on the Judiciary. We have a couple of different things in front of us today. We're going to hear from two reports, and then we're going to move on to a work session on LD 1572. And but as always, we will start with committee member introductions. And Representative Babin, would you like to begin?
Thank you, Madam Chair. Good afternoon. I'm Representative Mark Babin. I represent House District 3, Northeast Aroostook County.
Good afternoon, everyone. My name is Ellie Sato. I represent House District 109 in the beautiful town of Gorham.
Hi, I'm Adam Lee. I represent House District 89, which is downtown and New Auburn.
Good afternoon. I'm Jennifer Poirier. I represent House District 70, which is Skowhegan.
Good afternoon and welcome. My name is David Sinclair. I'm here for the people of House District 50, the city of Bath. Good afternoon, everyone. I'm Rachel Henderson. I represent the people of House District 78, which are the beautiful towns of Bethel, Byron, Milton, Hanover, Roxbury, and my hometown of Rumford.
Good afternoon. It's good to see everybody. I am Danny O'Halloran and I represent the good people of District 20, which is the industrious city of Brewer.
Hi there, I'm Dave Hagan, Senate District 10, 12 towns surrounding Bangor, but not Bangor.
Good afternoon. I'm Amy Kuhn. I represent House District 111, which is most of the town of Falmouth, and I serve as the House Chair of the committee. Welcome.
Welcome, everyone. My name is Ann Carney. I serve as the Senate Chair of the committee, and I also represent Senate District 29, which includes South Portland, Cape Elizabeth, and some of Scarborough. Representative Caruso, welcome. Would you like to introduce yourself?
Yes, thank you. Apologize that I was late. I'm Elizabeth Caruso. I represent House District 72, which is much of northern Somerset County. We welcome you here.
And so we'll start our work today with receiving a report presentation. The report presentation is from the Criminal Law Advisory Commission. It is a report on a question we raised for them regarding statutes of limitations and sexual offenses. And we're joined by Laura Ustak. Thank you very much for joining us this afternoon.
Thank you. Good afternoon, Senator Carney, Representative Kuhn, members of the committee. My name is Laura Ustak, and I am an Assistant Attorney General in the Criminal Division of the Attorney General's Office. But I'm here today in my capacity as Chair of the Criminal Law Advisory Commission. And as you know, Chapter 479 directed the Criminal Law Advisory Commission to take a look at the statutes of limitation that apply to sex offenses in the state of Maine. And specifically to address whether or not, and I'm quoting from the statute here, whether parity exists between the statutes of limitation established in Title 17A, Section 8, subsection 1B, and Section 8, subsection 2A, as well as whether the extended limitation periods established in these provisions should apply to any other sexual offense crimes in the state. You have the report of CLAC in front of you, and I had asked your analysts to include with that report the materials that your analysts had developed for you as you looked at recent legislation pertaining to statutes of limitations and sex offenses. Rather than read that for you, because you can read it yourselves, what I figured I'd do is just talk to you for a few minutes about statutes of limitation to make sure that everyone's on the same page and has a basic understanding of what we're talking about. I apologize if this is old news for you. But I find that often we're not using the same definitions or operating from the same experience. So sometimes it's helpful to start there. So I thought first I'd just give some quick definitions, provide a super quick historical overview, tell you where we are now, and then identify the couple of places where CLAC, the Criminal Law Advisory Commission, identified some possible incongruities that you might want to address. So some quick definitions. What is a statute of limitations? Turn that phrase around. It's a limitations statute. Think of it as a deadline. It's a limit on when the state can prosecute somebody. It runs from the date of the criminal conduct in criminal cases. And I make that distinction because I'm not talking about civil cases at all. And I know you as a committee and the legislature as a whole has addressed statutes of limitations with respect to civil proceedings as well. This is not about civil proceedings. This is only about criminal prosecutions. It is a defense. A defendant can raise the statute of limitations and say, hey, state, this conduct, even if it happened, is outside the statute. The statute has already run. So a defendant can raise it as a defense, and then the state has to prove beyond a reasonable doubt that it occurred within that time period. So that's something that the state always has to be ready to prove beyond a reasonable doubt. Usually it's a set time period, most often expressed in years. It can be tolled or suspended. So even though, you look at the statute and the two things that jump out at you probably in the current statute are 6 years and 3 years. Well, there are certain things that can interrupt it and put it on hold for a period of time. For example, if the accused person leaves the state, and that can extend it for up to 5 years, or if the prosecution is actually pending, that would toll the statute. So why do we have statutes of limitations in the first place? Why don't we just let the state prosecute anybody for criminal conduct into perpetuity? Well, it is a limit on what the government can do. Statutes of limitations recognize that evidence gets stale, witnesses die, memories fade. So it does limit how long the state has to prosecute somebody. It does encourage timely investigation because of that. On the other hand, however, the states and federal governments, jurisdictions recognize that there are some types of conduct that are so terrible that the state has an interest in not being limited. And the most obvious example of that, and the one that's been on the books for decades and decades, is murder. If you go back before the inception of the criminal code, the crime of murder had no statute of limitations. That can always be brought. And just one more definitional detail. I'm only talking here about statutes of limitations that apply to adult crimes. I'm not talking about juvenile offenses. We'd be in Title 15 in the Juvenile Code. There's a slightly different statute that applies there. And CLAC did not look at that. And the recent legislative changes that have been made did not address the Juvenile Code. So you find Maine's statute of limitations in Part 1, Chapter 1 of the Criminal Code. And that sounds like a kind of a nerdy little detail, but to me, why that stands out is because it's so fundamental. It's such a basic rule that they put it in Part 1, Chapter 1, which is where you find the general rules that apply to crimes throughout the criminal code, and that also live in other statutes outside the criminal code. So this statute of limitations thing, this limit on when the government can prosecute somebody, applies to crimes throughout Maine statutes. So super quick history. Prior to the criminal code, and when I say prior to the criminal code, I'm talking about 1975, when the legislature adopted a revised criminal code and created Title 17A. There was a general statute of limitations of 6 years. And that applied to all crimes except murder, manslaughter, treason, and arson. So think back to what I said a couple minutes ago about, well, there are some crimes that are so horrible that the legislature, reflecting the opinions and ideas of the public, has decided that there are some crimes that are so terrible the state retains an interest in prosecuting them. So those were the 4 that were accepted: murder, manslaughter, treason, and arson. when the criminal code was adopted in 75, the legislature created a different sort of structure. That's when the criminal code adopted the classifications A, B, C, D, E, which you're used to hearing by now. And it applied a general statute of limitations of 6 years to class A, B, and C crimes, and a shorter statute of limitations to class D and E crimes. Well, why the distinction? Well, class D and E crimes are less serious than class A, B, and C crimes. So the state has less of an interest in prosecuting those crimes for a longer period of time. Again, murder was the exception. There's no statute that applied to murder. And there was also an exception for misconduct by public servants while in office and for 2 years afterwards. So the legislature recognized a special statute of limitations pertaining to crimes committed by people in that category. Since there have been a number of amendments to these statutes of limitations since 75, a couple of them are super technical. I'm not going to address those at all. The ones I am going to address for you are just those that pertain to sex offenses. So again, this is going to be super quick. In 1991, the legislature eliminated the statute of limitations for incest, rape, gross sexual assault, which was previously called gross sexual misconduct, but only for those crimes if the victim was under 16. Notably, incest was a Class D crime at that time. So that was the only, if you can, and I'm using these terms without a moral judgment. Class D is a lower level crime, okay, in quotation marks, because it's in the misdemeanor level classification. So that was the only lower level crime that was removed from the statute of limitations, and that was in 1991. In 1999, the legislature added 2 more crimes to that category of sex crimes for which there was no longer a statute of limitations. They added unlawful sexual contact and sexual abuse of a minor, again, for victims under 16. So no more statute of limitations. A little digression here. When I say no more statute of limitations, that doesn't mean backwards into infinity. Okay, you probably know again from your work on these laws that the legislature can't resurrect crimes for which the statute, or for which, if the deadline is passed, can't bring it back. Okay, so this extended statute applied to crimes for which the statute had not yet expired and for crimes that would be committed on or after the effective date of the legislation. So every time I say the statute's been extended or the statute's been eliminated, we're only talking about those crimes for which that deadline has not already passed. So that was 1999, unlawful sexual contact and sexual abuse of a minor for victims under 16, no more statute of limitations. In 2013, the legislature changed the statute of limitations with respect to unlawful sexual contact, gross sexual assault, only if they were class A, B, or C, so felony level sex crimes, without regard to the age of the victim. But they didn't eliminate the statute entirely. It was extended from 6 years to 8 years. Okay, so now this captured a different group of sex crimes against a different group of victims, victims older than 16. In 2019, the legislature looked at that same category, unlawful sexual contact and gross sexual assault, class A, B, or C, victims 16 or older, and extended that 8 years to 20 years. And then in 2023, the legislature looked back to the changes that had been made in 91 and 99. And these were sex crimes for children under 16. And eliminated, or what they did was they changed the 16 to 18. So where previously the statute of limitations had been eliminated for children under 16 with respect to those sex crimes, they changed 16 to 18. So now we're talking about sexual assault crimes against persons under 18. At the same time, the legislature added unlawful sexual touching and sexual exploitation of a minor to that category of crimes for which there is no statute of limitations if the victim is under 18. And then in 2025, the most recent legislation and the legislation that directed CLAC to take a look at these changes, the legislature added aggravated sex trafficking, but only if it was a class A or B crime, to the 20-year category. So now, I mean, that's a lot of moving parts, right? Now let's go back to what do we have? What does this leave us with? We still have that really basic structure that we had at the beginning of the criminal code in 75, where we have a 6-year statute of limitations for A, B, and C crimes, a 3-year statute of limitations for D and E crimes, and then we have special rules for sex crimes, murder, that kind of funky little category of misconduct by a public official. And then there's a kind of an interesting little exception that has to do with breach of a fiduciary duty that is actually a discovery rule that's pretty unusual in criminal law that you find in civil law, but you can see why it exists. If you have questions about that, I can talk to you about that. Okay, so we've got 6 years for A, B, and C, 3 years for D and E, 20 years for gross sexual assault or unlawful sexual conduct if they're an A, B, or C crime, without regard to age of the victim, 20 years for aggravated sex trafficking if it's an A or B crime, and then no statute of limitations for murder and sex crimes against victims under 18 if it's incest, unlawful sexual contact, sexual abuse of a minor, rape or gross sexual assault, unlawful sexual touching, or sexual exploitation of a minor. Okay, so that's where we are now. So when CLAC looked at this, one of the things we tried to think about, we looked at how it started out at the beginning. More serious crimes have a longer statute of limitations. That makes sense. The rationale for creating longer statutes for sex crimes, particularly sex crimes against children, is a little bit different. It's a combination of both the seriousness of the offense and the way in which these types of crimes are disclosed. Because again, you know from your work, there's delayed reporting. And for any number of reasons, you've got very vulnerable victims who may be in a continuing relationship with the offender. There's a lot of trauma involved. They may not be able to disclose. They may be afraid to disclose, all sorts of reasons. So there are reasons for straying from the strict A, B, and C going 6, D and E going 3. And I think what you can see from the way in which the legislature has added sex crimes to their own special categories and extended those limitations period, how that policy has come in to change that general 6 and 3 rule. So what we did is we said, we tried to do what you directed us to and said, well, has there been anything left out, or is it anything in a category where it shouldn't be? And one of the things we noticed was that aggravated sex trafficking against minors is included in, and I'm trying to get this right because it's included in the 20-year category as opposed to other crimes against minors, which are in the no statute of limitations category. Which is fine. You could put it there. That's your policy call. We're just, trying to identify that for you. But what that highlighted for members of CLAC was, well, here you have a very serious crime, a higher level crime that has a shorter statute of limitations than much less serious crimes that are in the no statute of limitations category. Because if you look at the category for which there is no statute of limitations, it runs the gamut, A, B, C, D, E, as long as the victim is under a certain age. But then you have this kind of outlier of the aggravated sex trafficking that's in the 20-year category, even though it's a crime against a young victim. So that's one thing that we noticed, that might be addressed. One of the other things that we talked about, and am I going too long? I'm sorry.
No, you're providing us with a lot of great information, but I think a committee member may have a question for you, and I just thought it would be better to take them as we move on from one topic to another. Representative Lee.
I was just trying to understand the policy rationale for that, and I don't know if you could situate me timing wise, that application of the 20-year statute of limitations to aggravated sex trafficking of a minor. Do you know when the legislature did that?
That was just done.
Okay. And then the other crimes that have no statute of limitations, when was the statute of limitations eliminated for those?
So, starting.
Your mic is off right now.
Sorry, starting in 1991 is when the legislature started to eliminate the statute of limitations for different types of sex crimes. So in 1991 and 1999 is when the legislature first eliminated the statute of limitations for victims under 16. Yeah, it's in it. What I'm giving you now is a very condensed version of the analyses that your analyst has done for you, both on what became Chapter 479 and the public law Chapter 475, when that 16 was changed to 18.
Representative Henderson, did you have a question?
Yes, thank you, Madam Chair. And Representative Lee, I can get you a face-to-face with a sponsor of that bill from last year if you'd like. For the aggravated sex trafficking, yes, it was. And a question for you, thank you very much for the timeline on that. And it seems that there's a document in front of you that kind of outlines that timeline. Is that something that we as committee members could get a copy of?
Sure. These are just my notes. I'm happy to give these to you. It's actually just a condensed version of the more thorough stuff that you have from your analyst, but I'm happy to provide those to you.
And that does that, the more thorough in-depth, does that also give a timeline of all the different changes and overall, like, because you articulated it quite well and easy for us to understand what the landscape was.
I believe it does, but I'm happy to do this. And I do this because I need it simple.
Mhm.
So I'm happy to share that with you.
Great,
Sure.
thank you.
Representative Pugh, would you like to introduce yourself?
Thank you, Madam Chair. Good afternoon, everyone. I'm Dylan Pugh. I represent House District 114, which is part of Portland.
Thank you. And then your mic is off, but if you'd like to continue.
Sure, I'm almost finished. One of the other things we asked, or one of the other points that we noted is that commercial sexual exploitation of a minor, which is in section 855, is a Class C crime. And that does not appear to be included in any of the extended statute of limitations categories. Since it is not, it is subject to a 6-year statute of limitations. So if you wanted to address a crime against a person under 18 and include it in one of the extended periods, that would be one statute to look at. One of the other things we talked about is
Just one moment. I think Representative Caruso may have a question.
Thank you for this. So, we had actually discussed this the last session about, bringing these two areas up to no statute of limitations. And for some reason, I believe I'm not sure where it came from. They said, is there a reason why we couldn't do that? Maybe I could just ask you that. Is there a reason why we couldn't bring these two categories up to no statute of limitations?
I'm
So
sorry, which two
The ones you
categories?
said, the aggravated sex trafficking against minors that you mentioned before, and then also this commercial sexual exploitation of a minor or a person with mental disability.
Is there a reason? I'm sure there are policy reasons why some people would not want there to be no statute of limitations. I think you could, if you wanted to move all sex crimes against children under a certain age into the category of no statute of limitations, you could certainly do that. I think that's the direction the legislature has going, or has been going. One of the things that we pointed out in our report is, the challenges that come along with that. I think it's good that the legislature directed CLAC to look at this and to work with you on this, because one of the difficulties is the rules are the rules are constantly changing, and you look at the statute and you don't know whether you're a defense attorney or a prosecutor or a law enforcement officer or a victim or the defendant. You don't know which statute applies to you. Because even though it says it may say no statute of limitations, well, that's not necessarily so, because you've got to go back and look at when the law changed. When the law changed isn't in the book, it's not in the main revised statutes. It's buried in unallocated language, which you have to know to look for. And the unallocated language itself refers to effective dates without naming a date. It just says on or after the effective date of this statute. So I know that's the way statutes are written, but there are statutes that say on or after this particular date, this is the statute that apply. These are the rules that you apply. One of the things CLAC recommended is if you're gonna dip into the statutes of limitations at all, let's figure out what those dates are, because people are making charts and just adding years on and looking at the dates of conduct. It's hard to figure out. So, sorry, I strayed from your question. Is there a reason you can't do it? There are policy reasons you might not want to, but there's no legal reason you couldn't.
Great. Could I have a follow-up question to what you just
Yes.
said? So we're talking about dates. Assuming, let's say hypothetically, we move to no statute of limitations. But what you're saying is we need to bring clarification to dates. And in my mind, and maybe you could help me because I'm not an attorney and I don't prosecute. At what point is the victim's not valid? I just don't see it. There's a certain date and all of a sudden their violation and the crime that was done against them is not valid.
That
I'm not
Yeah,
explaining it.
no, but that sounds like it also might be a policy question that we would explore at a public hearing rather than in the receipt of a report. But it's a good question to be thinking about. After we're done hearing from the report, we'll have a chance as a committee to discuss whether we want to generate committee legislation in response to the information we're getting, and that might be a better time to explore these
Okay.
questions.
Great.
Thanks.
And maybe at that time you could, it would be nice to know how they come about thinking about determining dates.
Janet is, I think, willing to help us with that.
That was the most helpful overview of statute of limitations I've ever heard, by the way. I just want to let you all know that you have, if you wanted to see all of these, on page 9 of your book is where you can find the statutes of limitation. And I just wanted to let you know, since the general focus here is sex crimes, if you look on page 9, I'll wait till lots of people have it out. And I'm really grateful to Eli that he secured these for us. If you look, it's section 8 of the criminal code is called statutes of limitation. You're going to look at 1B, and that is the certain sex crimes against minors who are under 18 that have no limitations period. And then if you go down even farther to 2A, these are the certain sex crimes that have a 20-year period. So if you just wanted to follow all the ones that exist right now. But as to answer Representative Caruso's question, as AG Ustack said, and much of the information buried in the middle of it was the fact that there are constitutional limitations to what happens when you change a statute of limitations. So she mentioned over history from 1975, the criminal code on, different changes in 91, 99, et cetera, and so forth, when a limitations period was extended. But under the Constitution, you can't allow somebody to be prosecuted for a crime whose limitations period has already expired. So if I committed the acts that could subject me to prosecution the year I was born in 1974, saying that, so you obviously know I didn't do that. And the limitations period at the time was 6 years. Once 6 years have passed, I can't now, the legislature can't today pass a law saying, well, actually, there's going to be no limitations period. So even though for many years, Janet, you thought you were free of prosecution, we're going to retroactively go back and snatch up that conduct and allow it to be prosecuted. So that's a limitation on what the legislature can do. So because of that, when you pass laws extending a statute of limitations, you put in clauses in unallocated language, which doesn't end up in the red books very clearly, except it might in some little tiny notes somewhere, which says this change applies only to new conduct and to conduct where the limitations period has not already expired as of a certain date, and that's the effective date of the law. And so for that reason, it's really confusing for someone to know which crimes, because all of these lists have been tinkered with. And then sometimes it said when it was the victim under 16. So maybe for some of the crimes listed in 1B, it's as of a certain date if the victim was under 16, as another date if the victim was under 18. So there's that level of confusion, which I think is what she's pointing out. I don't think AG Ustack is suggesting that you need to change any statutes of limitations to fix this problem. You could just fix the law so it clearly says after which date do which limitations periods apply. There are two specific things that Clack noted aren't in these lists where one might think they would go if you look at the legislature's potential logic for the rest of the list. And so those are kind of separate recommendations, but in addition, there's this problem with understanding where the dates apply. And if we can switch a little bit to work session mode, sort of work session on this
That's
report,
fine.
you have those kind of distinct recommendations. There's the two areas where CLAC noted following the logic of the other exception or other extended statutes of limitation, it might make sense for these two particular crimes against minors to also have no limitations period. So there's those recommendations. And then there's this recommendation about clarifying the dates. You have the authority. What's attached to your report is the law that led to this study. And so this is the one you passed last year, LD 1427, sponsored by a member of the committee. And section 2 of that law did direct Criminal Law Advisory Commission to create this study and to create this report for you. And the last sentence allows you to report out legislation if you so choose. So you can choose to adopt any or all of the proposals in the CLAC report. And I would only suggest, if you wanted to move forward, it's very easy for me to see how to draft the first 2 recommendations into legislation. I might suggest you give me time to work with AAG USDAC, who is an extremely busy person. I don't know how she ever sleeps ever. To maybe work on the date piece. It may be that that's not something we could get ready in time to get the bill printed and referred back if that's the avenue you want to go down. It may be, because she has great notes, that we can do that very quickly. But if that does take longer, that's something that could be considered as an amendment. During that process, I realize it's much better if it's printed that way, so everybody has notice for the hearing, but we might be able to send out a proposed amendment before the hearing or something like that. So I just know that we're on a short time frame. I keep hammering this drum, but it's a real drum. That there is a short time frame, and I'd like you to be able to consider any legislation that you think is important to report out. So I just wanted to give you that caveat.
So those 2 very discrete areas are, should aggravated sex trafficking against minors go in 1B with no statute of limitations, along with other sex crimes against children? And should commercial sexual exploitation of a minor, which is section 855, be included in either of the extended statute of limitation categories? Those are the 2 most discrete takeaways.
Yes, and for the commercial sexual exploitation of a minor, all the other minors are in the no limitations period. So if you're trying to decide between the 2, that's been the rubric that happened before. And I do want to give Representative Lee a lot of credit here. He was the one, I think, who proposed this report by CLAC, because you had the bill before you, 1427, about one specific offense. And he said, are we missing any? So this, I think, really thorough report helps you maybe feel better that, at least for minor offenses, if you address these 2, you're not missing it. That makes sense.
Representative Lee?
You said something nice about me, and so I'm gonna have to make you hate me. As I'm sitting here perusing 17A, I'm just sort of taking that those 2 sections we're talking about are in a completely different part of 17A from the other sexual exploitation crimes for children. And that conjures for me a question whether we should be looking at a whole reordering of 17A to make it make more sense, particularly as it regards the statutes of limitations.
I would say not now.
Good answer.
There's a method to the madness of why certain crimes are in different chapters.
But I also think the fact that those 2 are. Sorry, I would also say the fact that those 2 crimes involving minors but are still sexually related offenses are not in these extended statute of limitations, I would posit is because they aren't in the chapter with the other sex offenses. And I know that I personally, when I was looking at least the first bill, I was focused on that chapter. Others before me may have done the same thing, or other legislators may have done the same thing. And that could be why those 2 were missed, which is why I think it's really great that CLAC took that overall look. So you could make the decision where you think those 2 crimes belong.
Go ahead.
I'm curious if CLAC had a conversation about whether those two crimes are somewhat policy distinct from the other sexual exploitation crimes. I know you're going to avoid the policy question, but whether they are sufficiently distinct.
We did not. We just looked at whether or not they were sex crimes or sex crimes against children that may not have been picked up. And that's part of the beauty of CLAC is that we have a bunch of practitioners around the table, defense counsel, prosecutors, judges, and we can say, okay, have we missed anything? And we do bring that collective experience to our discussions to advise you.
Any other questions, committee members? Did you have anything else you wished to share with us? Thank you for the excellent report.
You're welcome. No, I mean, there are some more technical details in the report, but I'll leave that with you and your analyst, and I'm available for any questions.
Thank you. Let's just see if there are any questions before you leave us this afternoon. Any final questions, committee members? Okay, I'm not seeing any. Thank you very, very much.
So I don't know if you want to talk now or have the other report, although the other report is tied to your work session. So maybe now I leave that up to you about whether you want a committee bill or a few committee bills on this topic.
Okay, so committee members, the question is, we've heard about two specific changes in the statute of limitation that we could make. One in aggravated sex trafficking, which is 17A 852. And the other, commercial sexual exploitation of a minor or person with a mental disability, that's 17A 855. And so if a committee member wished to make a motion that we report out committee legislation to make those two changes, that would be appropriate at this time. Representative Caruso?
Thank you, Madam Chair. I will make a motion that we report out legislation to remove the statute of limitations for those two areas that were mentioned.
Wait, remove the statute of limitations or? Yes, okay, thank you. Seconded by Representative O'Halloran. Let's see if there's any committee member discussion. I did want to also finish the thought, which is that we would also consider making changes that would address the specificity regarding the dates at which the various changes in the statute of limitations applies. Because if that's written in the statute books, it's crisp and clear and easy for people to answer those questions without a whole bunch of legal research. And as Janet indicated, we might not be able to get that language prepared in time to submit it to the reviser. These other two are pretty quick and easy. And so we could send this to the reviser and then consider work on the interim before we have the public hearing on that other piece of the specific dates and present that as an amendment to the bill at the public hearing. So those are what I see as the one recommended pathway. Representative Lee.
I think you just covered this, but I just wanted to make sure that we're anticipating with what would be those, I think, two separate bills, right? One to do the two eliminations of statute of limitations and then the dates that both would get a public hearing.
I was actually thinking that we would do one bill because the more we start a new bill, once all of the research for that third item is done, we may run out of time. And so what we would do is we'd have one bill pursuant to the motion made by Representative Caruso. And then we would ask Janet if she could work on an amendment to that bill and post it prior to the public hearing so that people who were appearing to testify on these two statutory changes could also speak to the clarification within the statutes of the specific statute of limitation dates. Does that sound?
Yeah, I think my asking that question was mostly focusing on definitely, I know sometimes we can proceed with committee legislation without a public hearing, but I definitely want a public hearing, particularly noting that CLAC didn't really have the conversation of whether those two crimes policy-wise belong.
Yeah, we would have a full public hearing on the policies underlying those two changes, but also on the policies regarding the amendment that we're anticipating and why it's an important policy to have those be clear in the statute. Janet, is there anything else you want to share?
I just wanted to be sure you're all on board with that whole proposal, which is printed with the two changes, publish an amendment to the interested parties list before the hearing. And I did have one more question of whether you wanted that disclaimer language that you haven't taken a position. It sounds like Representative Lee does.
Yeah, the language clarifying that we are voting to request the legislation and not voting on the merits of the policy encompassed therein. Okay. And so Representative Caruso, is that an acceptable amendment to your clarification to your motion?
Yes, it is.
And to your second, Representative O'Halloran? Okay, thank you.
I have a question.
Yes.
This is just a question for Janet. On your printout that you gave us, can you just clarify how that is changing now, given this amendment, if it were to go through?
So there's two different bill analyses and they're at different time points. The most recent is the one for 1427, which is what led to the enactment of this law. But both of those have in additional information or issues for consideration. I call it different things at different times. The legislative history, and absolutely before you vote on this, I will give you more information. I think it's easier to see actually what's proposed to be changed if you look in the book on page 9. So on page 9, statute of limitations, 1 paragraph B, which has not, this law has not been updated to reflect 1427, but I think the proposal is that both aggravated sex trafficking of a minor and commercial sexual exploitation of a minor be added to 1B, which is the one provision that says there is no statute of limitation, and that's because they're sex crimes against minors. What you did last year was put aggravated sex trafficking, I think A and B into 2A, which is the 20 years one. So it would be, you'd keep it there if the victim was an adult, but if the victim was a minor and it's aggravated sex trafficking, it would go up into the no statute of limitations category. Does that answer your question? Okay.
Are there any further questions? Committee members for Janet? Representative Henderson?
Thank you, Madam Chair. Am I to understand this is intended to be one bill or was it for two separate bills?
For one bill. Any other questions? Okay, not seeing any. So we have a motion, a second. Am I correct? We can just do this with a show of hands. All right.
But just have to hold them up while I
Okay.
write you down.
So all those in favor of reporting out the legislation as described, please raise your hand. Just creating a bill. Yep.
Okay, that's everyone. I'll just write it down.
Great. Thank you.
Okay, the next report I think is ready.
Great. So next, we're going to hear from the Maine Commission on Domestic and Sexual Abuse, their report on strangulation and suffocation offenses. And I'm wondering, is it Andrew Mancuso speaking to us?
Some presents. Good
Welcome.
afternoon. I'm Andrea Mancuso. I'm the Public Policy Director for the Maine Coalition to End Domestic Violence, and I'm joined here today by Jen Annis, who's the Project Coordinator for the Violence Intervention Program in Cumberland County. And
Could you move the microphone? Just say
Yes.
that again.
Sure. I'm Andrea Mancuso. I'm the Public Policy Director for the Maine Coalition to End Domestic Violence, and I'm here with Jen Annis, who's the Project Coordinator for the Violence Intervention Project of Cumberland County. And we are here to represent the Abuse Commission in the report back.
Thank you. I wanted to just say a little bit also about my background. So I'm currently the manager of the Violence Intervention Partnership and a member of the Maine Commission on Domestic and Sexual Abuse. But in the context of today's discussion, it might also be helpful for you to know that prior to that, I was an advocate for Through These Doors, which is Cumberland County's Domestic Violence Resource Center for almost 20 years and supported thousands of survivors of domestic violence, many of whom have experienced suffocation and strangulation as part of their experience. Additionally, I've attended the advanced and the master's course for the Institute of Strangulation Prevention and have helped to coordinate hundreds of trainings since I've returned from that for local multidisciplinary teams and have been the primary domestic violence trainer at the Maine Criminal Justice Academy for the basic law enforcement training program on domestic violence for the past 20 years. So all that to say, I have been a member of this strangulation and suffocation action group, and Andrea has been the chair of the committee. The action group formed, as you all are aware, LD 1572, an act regarding prosecution standards for non-fatal strangulation or suffocation in domestic violence cases, was carried over, and your committee asked the Abuse Commission to look at several issues and report back to you all. So that's why we're here today. The Abuse Commission created an action group based upon that request, and the action group took a look at and reviewed several items that you asked, which was whether and how to relocate strangulation out of the current aggravated assault statute, whether and how to define suffocation in Maine's criminal code, any need for mandatory training on strangulation and suffocation for the criminal legal system partners, and how strangulation and suffocation are addressed in statutes in other states. The action group was comprised of Andrea from the Maine Coalition to End Domestic Violence, Kelly O'Connor from the Maine Coalition to End Domestic Violence, Alice Clifford, Penobscot County District Attorney's Office, Shira Burns, Maine Prosecutors Association, Laura Ustak, Maine Office of the Attorney General, although please note that Laura was there for technical assistance and legal input and does not represent the position of the Office of the Attorney General on this task force. Michael Johnston from the Maine State Police, Maggie MacArthur, Next Step Domestic Violence Organization, Melissa Martin from the Maine Coalition Against Sexual Assault, Chief Mark Hathaway from the Bangor Police Department, Kara Cookson from the Maine Attorney General's Office, myself, Chief Doug Snyder from Booth Bay Police Department, and Representative Holly Stover. We're all a part of our action group. We convened, we had six full meetings of the action group. And on one of the occasions, we specifically had some medical expert consultants join us to hear a little bit more about the medical impacts of strangulation and suffocation. Many of the people that joined us, you do have it in your full report and also the PowerPoint outline, the names of all the medical experts that joined us. but many of them participate in multidisciplinary training teams across the state, not only for other medical professionals, but also for law enforcement advocates and prosecutors. They also have, many of them testified as as expert witnesses in criminal cases, in civil cases regarding strangulation, suffocation, sexual assault. So we utilize those individuals to help ensure that we were looking at the accurate medical concerns around strangulation and suffocation as we went forward with the actions in our report.
So across our meetings and conversations, the action group had the benefit of the Abuse Commission's 2012 report on strangulation. That report over a decade ago served as the basis for the state moving forward with expressly codifying strangulation as it currently exists in Title 17A, Section 208, the aggravated assault statute. We took a look specifically at how the main statutes are constructed around assault crimes with specific focus on the aggravated assault statute where strangulation currently sits. We had the benefit of hearing about jury instructions for that statute when it is charged by prosecutors. We looked at a compilation of statutory approaches from all other states in how they address codifying strangulation and suffocation for those states that do codify suffocation. And we were able to see not only how many and how they structure that, but also how they define those things. All but one state currently specifically mentions strangulation as a crime in their criminal code, and quite a number also expressly similarly codify suffocation at this point. So that's the bulk of the material that we had sort of written before the action group. We've just included in your presentation, the highlighted piece in the aggravated assault statute where strangulation sits. So it's in paragraph C of Title 17A, Section 208. As you move through that paragraph, you'll see sort of starting in the middle, it names some of the how you could be charged with aggravated assault. And one of the ways that you could be charged with aggravated assault is the use of strangulation. And for the purposes of that, what we mean when we say strangulation is impeding the breathing or circulation of the blood of another person by intentionally, knowingly, or recklessly applying pressure on the person's throat or neck. And that substantially tracks with how other states are also defining strangulation in their codes. So you have sort of the full report in front of you. What you don't have in front of you that is in the electronic document that was sent out by Janet yesterday is Appendix E, which is the 2012 strangulation report from the Abuse Commission. That's on its own 50-something pages. So it's in the electronic version, but I did not print it out for you today. I think one of the most helpful things in that particular appendix from over a decade ago is, like we did in this round, the Abuse Commission over 10 years ago did a compilation of how all states were handling strangulation and suffocation at that time. So it's an interesting little comparison to see actually how nationally states have evolved over a decade plus. Broad strokes, the Abuse Commission has concluded that responses to the use of non-fatal strangulation and non-fatal suffocation as methods for committing assault in Maine could be improved. The Abuse Commission has concluded that the structure of our current aggravated assault statute does not provide a mechanism for the state to have quality data on the prevalence of strangulation or suffocation in our criminal legal system, or how the legal system is responding to that. The Abuse Commission notes that at least 20 other states have criminal codes where strangulation is a separate crime. So instead of being in 17A 208, it might be in its own separate statute. You would just charge strangulation as opposed to charging aggravated assault. And many other states who do like we do and have it in a broader aggravated assault statute, structurally, it's in a different paragraph with a specific reference. So most other states that have codified strangulation have done it in a way where you can better pull data on when it's charged and what is the response in the criminal legal system when it is charged. So the Abuse Commission is recommending that strangulation be separated in the aggravated assault statute to keep it in the aggravated assault statute, but to drop it into its own paragraph to allow for better jury instructions and data collection to inform future system responses. That's strangulation. We're happy to take them as you go along.
Thank you.
Sure.
I followed you until this last thing. I thought in the third bullet, you said that Maine has it in its own subsection of paragraph. But you're just saying you wish it would be in its own paragraph.
So 20 other states have it in its own statute. There are a number of states who do like we do, where it's in the aggravated assault statute, but it's in its own paragraph. So when you charge it, it might be 208 subparagraph 3, as opposed to just being 208. And so what we're recommending is actually that approach, that we sort of take this language, and you'll see in the next 2 slides.
Okay.
What we're actually recommending in terms of statutory language for strangulation and suffocation to sort of drop it down. So each of them are codified independently in their own subparagraphs. So with respect to suffocation, the Abuse Commission is noting that common types of suffocation observed in the field by first responders, to include medical professionals, advocates, and law enforcement officers, would not be considered strangulation as currently defined in Maine law. Some of the ones that were specifically noted by the medical experts that we consulted with are listed starting at the bottom of page 4 on the report. Those include airway obstruction by covering the nose and mouth with hands or pillow, mechanical asphyxia by positioning a victim such that their upper body can't expand, like folding a person down in a chair or confining a person in a small space, being held face down while the perpetrator sits or lays on the victim's back, which prevents chest expansion, or holding down while the perpetrator sits or kneels on the victim's chest, preventing chest expansion. Those 4 were the most frequently observed presentations of suffocation that are the medical experts that we consulted with brought forward. The medical experts were unanimous that there's no clinical basis to consider suffocation any less life-threatening than strangulation. We note, and it's reflected in the state-by-state compilation that you have in the back of the report as Appendix C, I think. At least 28 other states explicitly name suffocation in their criminal codes, like we currently do with strangulation. The Abuse Commission is recommending that like strangulation, suffocation should also be explicitly named in Maine's aggravated assault statute. So turning the page on your PowerPoint presentation, and this is reflected in Appendix F in the full report. This is just sort of the cut and paste of what we're recommending the Maine legislature do as an amendment to the aggravated assault statute, which is to take the strangulation language out of that paragraph C and drop it down into a 3 and 4 for strangulation and suffocation, respectively. So strangulation's definition would stay the same. It's just dropped down into its own paragraph. And suffocation, in looking at the ways in which other states have codified suffocation, we're recommending that you codify it as a person impeding the breathing or circulation of blood by intentionally, knowingly, or recklessly applying pressure on another person's chest or blocking another person's nose and mouth. So that's our statutory recommendations for strangulation and suffocation, and we're going to move to training recommendations next. And Jen's gonna.
Before you go there, let's see if there are any questions on those recommendations. Senator Hagan?
Thank you much. Was there any recommendation on making this into a Class A felony?
We did not reach that issue as an action group. The commission and the action group decided to focus on those areas where we felt we could be most useful in making the most impact in the time that we had to have our meetings and discussions and come back and report to you. The commission has authorized the action group to continue both to look at some of the other issues that came up in the public hearing on 1572 and to address anything that might come out of this legislature in response to our report. So that's on the list, but it's not something that we had an opportunity to get to at this point.
Thank you, Representative Lee.
I have like 4 questions, so
Okay.
I'll maybe
We're
just
ready.
ask 2 right now. I understand the problem that's being resolved by adding suffocation. What is the problem that's being resolved by dropping strangulation and suffocation out of that paragraph into their own separate paragraphs?
Yes, so that's a great question. It's data collection. So for example, in our state, we can see very clearly when stalking is charged and the results of stalking being charged. We can see with the data that by and large across the prosecutorial districts, when stalking is charged, there's a high proportion of convictions that come out of stalking being charged. So as we look at how can we improve criminal legal response to stalking in our state, I think both Jen and I would say it's probably not law enforcement. It's probably not prosecution at this point, because when they get it, they're actually pretty successful with it. It's identification and charging of stalking in the field by law enforcement that needs some support, right? And so you've seen over the last couple of years some changes to requirements in police policy that when law enforcement gets multiple complaints by a victim against the same person, they should pull all of those reports and look across incidents for potential stalking crimes, right? We know to focus a response improvement efforts in that vein because we can see the data across the criminal legal system. You can't do that with strangulation. I don't believe there is anybody sitting here today that could tell you, they're not gonna be able to tell you how many times is strangulation charged in our state. And if it is charged, what then happens to it? And are there particular deficiencies in particular jurisdictions, either on the law enforcement end or the prosecutorial end or within the court response?
And the second reason was also to simplify jury instructions. It was a little bit clunky, the way it was written, and very confusing for jurors to understand the actual directions when it came to strangulation. So by pulling strangulation out separately, it helped to clarify when a jury is getting the instructions when a case did involve strangulation.
We looked at the case law because that was an issue that had come up as part of the discussion around when you need to prove manifest extreme indifference to the value of human life, right? There's case law that it makes it clear that the way the aggravated assault statute is currently structured, you don't need to prove that as an independent element. If you can prove that you've strangled someone, you don't need to prove that second piece, right? But because of the way it sits in the aggravated assault statute, those words get put into jury instructions. And so we were actually able to hear about some of the jury instructions that are used with the language the way it currently is in the aggravated assault statute. And it's very confusing to your average layperson. Go ahead.
They effectively answered 3 of my 4 questions
Okay.
with that answer. The other question that I had was, in charging is sort of where my brain is at, is if there's some confusion about the issue of whether or not it's a strangulation or suffocation case, could a prosecutor charge both just regular aggravated assault, where you'd have to prove the indifference, and the strangulation or
Yes.
suffocation?
And that was, I think we had multiple conversations around that would likely be a prosecutorial practice.
Representative Sinclair, did you have your hand up?
I did. Thank you, Madam Chair. And I don't know if Attorney Mancuso accidentally or in the course of responding to Representative Lee may have touched on this, but it's clear from the recommended statutory changes to 208 that at least your committee's suggestion is that we remove any necessity of the states proving an actual injury. And it sounds like perhaps that was intentional, but I wanted to clarify that with you because that of course, is a policy decision, but I wanted to understand it from your perspective as well.
The current language in the aggravated assault statute says, right? Including but not limited to the use of strangulation, right? So bodily injury to another under circumstances manifesting extreme indifference to the value of human life includes ... the use of strangulation. And for the purposes of this paragraph, strangulation means impeding the breathing or circulation of the blood, right? So that is the bodily injury, and that continues through in the recommendation.
And part of that is, if I can follow up
Yes.
with that, because the, by impeding the oxygen deprivation to the brain is internal injuries that cannot be shown other than, by being able to show someone lost consciousness, for example, would show that they had lack of oxygen. So if you can prove that lack of oxygen, you may not actually be able to see the visible injuries, but they may have damage to the brain that may present in other ways that might not look like a physical injury.
Do you have a follow-up? Just quickly, and it may just be a follow-up on my misunderstanding either of Attorney Mancuso's response or of your response, but it sounded to me like Attorney Mancuso was suggesting that despite the way your suggested changes to 208 read, it sounded like you were suggesting that somehow actual injury would stay in there in terms of how the statute would parse. I think that that's not right, given that in creating a section 3 and a section 4, we'd expressly be taking them out of section 1, so there'd be no mention at all of actual injury. But it sounds like your colleague there at the lectern or at the microphone is suggesting that the courts should simply presume, the jury should simply presume that there was an injury, even one that can't be proven, simply from the fact of demonstration of an impeding of the airway or of the breathing. Am I understanding you both correctly?
I think that we're both saying the impeding of breathing, the impeding of the breathing or the impeding of the circulation of blood are bodily injury. Full stop.
Okay, thank you. Are there any further questions on this section? All right, I think we can continue.
All right, so Jen is going to move us on to recommendations with respect to training.
Thank you. So each year for several years, the biennial report from the Domestic Abuse Homicide Review Panel has highlighted strangulation as one of the lethality factors that occurs lots of times in the homicides that present. And in the 14th report, they said they observed that after the review of multiple cases involving fatal strangulation, in some of those cases, the dynamics, mechanics, and impacts of strangulation do not appear to be understood by the court or other parties, which highlights the need for additional training along with other reasons. But that report, all the way up through homicide, shows why we continue to need increased training around strangulation and suffocation. Additionally, early identification is essential to make sure that survivors get proper care and treatment that they need and are able to safety plan, as it's a high-risk lethality factor for future homicides, and to be able to hold the perpetrator accountable. The Training Institute on Strangulation Prevention continues to be the gold star standard. We have heard that many people have attended. I myself have attended and sent other training teams to attend. And when people return, they are motivated to make change and to ensure that other people are getting correct and accurate information. And the action group decided that it would be beneficial for Maine professionals to be able to continue to receive information and services from the Training Institute on Strangulation. Additionally, the action group recognized that statutory mandates around training can be cumbersome to implement and are often unfunded and may not be appropriate for long-term prioritization. So the action group is not asking for a statutory mandate. However, they are recommending that systems create a plan for ensuring professionals are appropriately trained by 2030. And this includes the Maine Criminal Justice Academy for all law enforcement officers, with an emphasis on creating opportunities for in-person trainings. The Maine Office of the Attorney General and the Maine Prosecutors Association for all prosecutors, investigators, victim witness advocates responsible for cases involving interpersonal violence. The Maine Judicial Branch for all judicial officers, mediators, and guardians ad litem. And the Maine Department of Public Safety Emergency Medical Services Board for all emergency medical service providers. Additionally, training should include at a minimum effects of strangulation and suffocation, laws related to strangulation and suffocation, and services available to victims around strangulation and suffocation. Training plans should include on how newly hired professionals will receive trainings within the first 2 years of their service. Each entity should adopt policies needed to ensure universal compliance with the training plan. And the Maine Sexual Assault Nurse Examiner Program at the Maine Department of Health and Human Services should continue to work with the Maine Coalition to End Domestic Violence and the Maine Coalition Against Sexual Assault to provide training, education, and outreach to medical professionals on all of the above topics related to strangulation and suffocation.
I will just also note that the Wabanaki Women's Coalition, which represents the tribal domestic violence and sexual assault programs in Maine, there's a footnote in our report that indicates the SAFE program should continue to invite them to participate as well, in addition to MCDV and CASA, though they have not historically opted into partnering with that program around.
Let's see if there are any questions on the training. I'm sorry, did I cut you off? Okay. Are there questions on the training? I have a question. I'm reading the report to say that you don't want to specify in statute the particulars of the training, but you want to direct the outcome to be proficiency? Or
We're not
neither in
asking the
statute?
legislature to take any sort of
Okay.
action on this particular thing. The Abuse Commission is statutorily directed to make recommendations to the legislative, judicial, and executive branches. And so how we would proceed, like to proceed at this point is to make sure this report gets distributed to all of those entities under sort of that statutory directive. And we have, I think, given a pretty decent lead time in terms of would like to see how each of these entities would propose ensuring that relevant professionals have the training by 2030, and how they'll have this important training provided to the folks that are serving in those entities in an ongoing way. And we know that we give you an annual report on the activities of the commission. And if for whatever reason there are implementation challenges, we can always come back to you.
Okay, thank you for clarifying that. Committee members, are there other questions on the report or the recommendations? Okay, not seeing any.
Thank you.
Thank you. Jana, this is maybe rejoin us. Sure. We're going to take just a 5-minute break and we'll be back at 2:30.
Thank you.
All right, we'll come back to the table, please, committee members. And I'm going to open the work session on LD 1572 and invite the bill sponsor up. Actually, Janet, did you want to frame where we are before the bill sponsor joins us?
Certainly. If you can dig out of your folder, the bill analysis and then the yellow sponsor amendment. As the bill was originally proposed, it included some of the training requirements that were alluded to in the report presentation you just received. It also included amending the aggravated.
Yeah, that's good.
Maybe a practice for tonight or something.
Folks, don't want you to listen to me. The bill also included amending the aggravated assault statute to specifically include suffocation, where it right now just includes strangulation. There would be language added to include suffocation. And if you look at the bill, that's on page 2 of the bill, in the middle of the page, section 4. So it did the training, it did that change. It also had some changes about whether the person had done prior conduct and whether that would be admissible in these cases. And then it would require reports about the charging of these crimes, which was difficult because they weren't in separate paragraphs of the statute. And I can explain that to folks if you have questions about that. Then the sponsor had a proposed amendment for the work session, which again, still in part A, this is the yellow handout, had training requirements. So that was all of part A. Part B, if you look, did have a change to the aggravated assault statute to take strangulation out of the paragraph that is currently about manifesting extreme indifference and make strangulation and suffocation their own crime, but they were combined. The Abuse Commission is now suggesting separating those out even further. But that proposal was before you. And then there were also some other proposals about elevating other crimes. And then part C had an evidence change to allow the prior bad acts, but with a lot more detail in the provision. And so I just wanted you to know that because it was a long time ago, that you did have the proposals about having aggravated assault, that statute specifies strangulation and suffocation either as part of the manifesting extreme indifference crime or as their own crimes, although they were combined. You did have that before you. And then you originally were going to have CLAC study this issue, but there were some concerns. You already had them studying something else. And so the Abuse Commission offered to provide this detailed work where they had studied the strangulation in the past. And instead of reporting out legislation requiring that report and then having it come back with a committee bill and everything else, where you wanted just advice on how to word the strangulation and suffocation, you carried the bill over and had me write a letter instead. So where you wrote a letter, there isn't authority from the letter to report out legislation, but you don't need it because you have the bill. So I just wanted you to know kind of what has been considered with respect to this bill before, and so that you know it's squarely within the scope of what the bill was proposing, only it's a much more streamlined version if you go with the recommendation you heard today.
All right, thank you. That's really helpful clarification. Representative Sober, would you like to join us? Perhaps you can update us on where you are with your bill.
Thank you, Madam Chair, and I want to personally thank all of you around this horseshoe, the amount of time and energy and thoughtfulness and energy that, and I said energy, that you've put into this bill and allowing us to go back and have the Maine Commission on Domestic and Sexual Abuse dive into this deeply and bring it back to you again. It's been an extraordinary effort, in my opinion.
And I'm just very grateful to all of you. That being said, what I would ask for the committee to do is to strike all the language of the original bill and replace it with the language provided to you today by the Maine Commission on Domestic and Sexual Abuse Subcommittee. The work that was described to you in the report that was given to you. Thank you.
All right. Are there any questions for the bill sponsor about the revised language? Not seeing any. Thank you. Thank you.
We do want to point out, hopefully you still have your red books around. Sorry, I can't do two things at once.
Take your time.
Okay. If we look on page 39, we'll find the aggravated assault statute. I just love these books. Can't help it. And this is the statute that the Abuse Commission is recommending you amend. It was proposed to be amended in the original bill and the sponsor's original proposed amendment. So if we look at aggravated assault, section 1C, that's the paragraph now where it says circumstances manifesting extreme indifference to the value of human life, including if it's strangulation as defined. You would be taking including strangulation out, making that its own paragraph D. So strangulation offenses would be aggravated assault. And then there'd be a paragraph E for suffocation offenses. I did want to point out that if you look on the very next page, on page 40, there is a separate crime of domestic violence aggravated assault. And if you were to look through that statute, it tracks the aggravated assault statute exactly, except that you charge it as domestic violence aggravated assault if the victim is a family or household member or a dating partner. So if you wanted to make this amendment to aggravated assault so that there's two more distinct ways, you might want to consider amending the domestic violence aggravated assault similarly to say, if you do one of these strangulation or suffocation offenses and the victim is a family or household member or dating partner, then it would be DV aggravated assault. And I spoke to Andrew Mancuso from the Maine Coalition to End Domestic Violence. I asked if that was something they would be recommending, and she said, yes, that made sense. But I defer to the committee on the policy of whether you want to do that. I just wanted to make sure I wasn't coming out of left field. Also, I will point out that the reviser's office will require me to rewrite a little bit the way it's proposed to be written, but I won't substantively change it, just move the words around.
Okay, thank you. Any questions on that, committee members? Representative Lee?
I don't know if it's on that directly. I'm just trying to catch up as to how we're gonna proceed or how we're proposing to proceed.
Mhm.
I get that we don't need to report out legislation, so there's not gonna be a new public hearing on this. I got one last session, but what we're talking about is, to me, a largely different bill. And so I'm not looking for us to have another public hearing, but I'd certainly like a work session and the opportunity to hear from some of the other interested parties, like we haven't heard from MacDowell or some others on what their thoughts are on the new proposed legislation. So I was just putting a bookmark in there right now.
I guess I took, Janet, your prior comment to mean that this language is really a subset of the amendment that was before us.
Yes, so the
Such that
sponsors
maybe we've heard
proposed,
from those folks. I'm just trying to
Yes.
clarify what information we need.
you did have folks from those organizations comment on the sponsors proposed amendment. And that did break out strangulation and suffocation as a different way of committing aggravated assault. It put them in one paragraph as opposed to separate ones. And so that proposal was before you. I think you have several options. And it's up to you whether you want to request an extension of the deadline for this bill as well. This bill is supposed to be voted by Friday, but that's really your decision, not my decision. You could vote to have it. We could schedule the language review and you could direct me to invite certain people to it. Or you could say, we want you to prepare the amendment and invite those people to a work session. Either way would work. But I'm just trying to keep in mind if you want to try and make that deadline, because I know that there are other bills that probably won't make that deadline. Just trying to give you options.
Thank you. Representative Lee, do any of those options in particular satisfy?
I just have some questions myself, and I
Mhm.
feel like those stakeholders are individuals that I would like to ask those questions of, and I don't know. We're getting this as sort of a report rather than, noticed as a work session, and so I'd like to hear from those stakeholders before we make a decision.
This was noticed
Okay.
as a work session, just.
Oh, was it?
Yes.
Okay. Well, I might change my feelings about that.
Yes, this is a work session.
I have feelings.
Let's just mull that over a little bit. Senator Hagan.
Thank you. I liked option 3 that you gave, and I agree with everything Representative Lee had said. I think it would be, I'd love to be able to pour over this stuff this week, by myself, and then formulate my notes and then do a work session and vote. And if you could even get it somehow extended past Friday, that would probably make things easier to flow well. And I'd be for that.
Option 3 was asking Janet to prepare an amendment and then come back and have a second work session when we have language in
Yeah,
front of us.
and then we can listen to the parties that are interested. Yeah.
Representative O'Halloran.
So does that then mean, like, if we're curious to hear how many prosecutors association feels about this, that we should wait to ask them, or can we ask them now, or?
I think we can ask if they're here in the room with us. Sure. Were there any other questions for Janet before we have Shira come up? Yep, Senator Hagan.
Whether it would be for Janet or Shira, I'd like to understand the process of going up to an A felony. Don't quite understand that, so I'd like to leave today understanding the bill in that area.
Okay.
Yeah.
Thank you. Shari, can you join us?
Shira Burns, Maine Prosecutors Association.
Thank you. Representative O'Halloran had a question for you, and then Senator Hagan.
Hello.
I'm also curious.
Could you put your mic on? Sorry.
I'm also curious about Senator Hagan's question, but I'm also curious on your thoughts on this bill and how you see it being beneficial to what you do.
Yes, I appreciate the question. And I have to first start by thanking Representative Stover on her amazing leadership on not only this bill, but really on domestic violence issues. She has been a go-getter. And we really appreciate that. For people that don't know, I did specialize in strangulation prevention in my time as a frontline prosecutor. I attended not only the advanced course on strangulation prevention, but also 2 master courses, including the first master course they ever offered. And I am a trainer on this subject nationwide, along with our state. So this is something that I really am invested in personally and in my position. We worked on this language with the Abuse Commission and the different people that sit on there from different angles. Obviously, Laura sat as a specialist for really technical issues. And we came up with this, and I think it will be very beneficial in the prosecution of strangulation and suffocation to have this language in our statute. And this is from obviously the perspective of prosecution and doesn't include all the policy reasons of why advocates, domestic and domestic violence support this. But from a prosecution standpoint, we did talk about jury instructions, and I actually got a lot of jury instructions. I asked for them from many different prosecutors who've prosecuted strangulation. Can I see your jury instructions? The jury instructions that we have now are really hard. I have that own experience, and almost every time I get a note back from the jury about manifesting extreme indifference to the value of human life, which I want to be like, it doesn't matter in strangulation. We have a law court case. If you meet the definition of strangulation, you're not proving something else of manifesting extreme indifference to the value of human life. That's a really hard wording to use for juries. So we wanted to do something that to simplify the jury instructions, because we do find that as being difficult. We wanted to do something that we're not changing the substance of the law, but what it is now. And I think that gets to Representative Sinclair's question and his point. And I understand what you're saying regarding the current law saying bodily injury to another, and we don't have to prove that anymore. What we found when we looked at it is the current law, what sits in statute now, is repetitive. And again, we wanted to clarify without changing substantive law. So bodily injury is actually defined in statute. There's 3 ways to meet bodily injury, and one of them is any impairment of physical condition. Any impairment of physical condition. Well, if you look at the definition of strangulation, it says impeding the breathing or circulation of blood. And what we unanimously found is that meets the definition of any impairment of physical condition. So again, it's not trying to take out things. It's really to clarify, simplify the existing statute. So that's what came up with the strangulation. Regarding suffocation, what we saw with strangulation when this was passed back, I believe in 2012 or 11, is that we were better prepared to respond to strangulation from law enforcement, prosecutor, from MDT approach. We do believe that suffocation will be the same thing. Suffocation is hard. We do try to, right now, prosecute it on subsection C. You absolutely need an expert witness to show why it is manifesting extreme indifference to the value of human life. So every time we have a suffocation case, you really need an expert witness to talk about the long and short-term effects of suffocation to meet then circumstances manifesting extreme indifference to the value of human life. Because we heard from medical experts that really isn't a difference between suffocation and strangulation regarding the what the effects does to your body. It is important, I think, to have its own crime that we can identify, and we do think the response in general will be better for victims. So we are very in strong support of this. Now, regarding the Class A. Yes, definitely.
Yes, just your microphone.
Can you tell me, do you think some people choose suffocation over strangulation for less evidence involved? There's not the same type of bruising?
Yeah.
necessarily?
I truly don't know that. I will say though, strangulation, 50% of the time, there are 0 marks. So, and that even is, that statistic stays consistent through when strangulation is used all the way to homicide. And so for visible evidence, and this is why this is going to get my point of the Class A, strangulation is one of the hardest crimes in my view. Sexual assault's very hard to prove. And again, we're going to get into all the dynamics of why I've said here a million times. We treat the court system because of the way the court, our rules have been created. We treat domestic violence the same as we treat theft from Walmart, from operating after suspension. Operating after suspension, you have an officer run the plates, their license suspended, they pull them over. Here's your evidence, here you go. And then it's just really policy decisions on what you do with those. That goes through the same court system as a strangulation case, as a suffocation case. And what we don't take into consideration is the power dynamics that come in with domestic violence, with our sexual assault crimes, and they go through the court system the same. It's really, really hard to prove these cases, not because they didn't happen, not because I don't believe victims, but because we have to follow the same rules we have to follow in any other cases for many good reasons. But the power dynamics are really hard. So my answer to the Class A is I would not be supportive, again, not because I don't think that these people that are doing these crimes it's horrible. And I absolutely look for very long sentences on them. I've reached it's a 10-year max. I've reached in State versus Perry, 9 years with a consecutive sentence because he did more than just strangle his victim. And so we can get those long sentences. Problem is they're very hard to prove. And when we start increasing classes of crimes, just like it's what I've said about why we don't want minimum mandatories on these, is because most people do plead. I mean, we've talked about statistics of jury trials. They're very low. We do want to reach resolutions, and most of those resolutions we want to reach because that's what the victim is asking us to do. Trials are really, really hard for victims, and I could be here for an hour of what a victim goes through when her abuser is being prosecuted for any crime, and even if that victim doesn't want anything to do with the criminal justice system, how that victim's life is uprooted in many different ways. So sometimes pleas are in the best interest for the victim. That's what we hear. And it will be a lot harder to get those pleas if we're a Class A crime. I think the focus really should be what can we do better for the victims in prosecuting these cases in the criminal justice response in general. And maybe that's looking at rules, things like that. We did just have a rule pass for the rules of evidence regarding forfeiture of wrongdoing. That's the big thing with domestic violence cases. So it's those kind of things that we really need to work on. And then once we get to a place where we can prove them and judges are handing out 10-year sentences and this body wants to say, well, you know what, 10 years really isn't enough. Let's go more. I'll leave it up to you at that point. At this point, I would not be in favor of a Class A.
Yes, follow up?
Yep, thank you. So you're not in favor if it goes through and Class A stays with it and then it goes to the big house, the big Senate, all of that. What's the process of this going to an A crime? Maybe I don't understand my own question.
The bill as written is a Class B, and that's what it is right now, and that's what we're supporting. If you change it to a Class A, I put my objections on here why I don't personally think, or the MPA wouldn't be supportive of it, but
It would also be just a very different bill that is
So the
beyond the
Class
scope
A
of what
part of the bill will be removed.
that's not in the bill.
It's in the original bill.
Oh, okay, it's in the
Okay.
original.
You
And
are
I was reading this old blue thing earlier, so.
Yes,
All right,
so,
thank
so
you.
the
clarifying.
proposal is to not do those things because you asked the Abuse Commission to look at the way it was written, and they suggested taking a different approach. So it's not even to do the yellow, it's to do much less, just what the Abuse Commission
Okay.
presented.
Thank
to
you. I was just confused.
No, understand.
Now I ain't.
Representative O'Halloran.
I'd like to ask a question that may not necessarily pertain to this bill, but pertains to one that we currently are working on.
No, we should be asking questions about
Okay.
this. Okay, let you go ahead, Representative Lee.
My question's not. Okay. I'll just ask the question.
okay.
So we've determined with the way that it's worded right now that strangulation is per se manifesting extreme indifference to the value of human life, right?
Yes, and State versus Saucier says that.
And help me, and I'm stuck on extreme indifference, and it's not as to intentional or knowing strangulation, it's to the reckless component. And I get that recklessness is sort of indifference, right, to injury or the potential to cause injury. How is it by and of itself the proof of reckless strangulation or suffocation if we pass this bill? How is that a demonstration that is per se extreme indifference to human life?
Well, I guess I would say is what this bill is doing doesn't change any of that. And it really was the medical expertise, I think, here in 2012 of why you guys were told how you do, as soon as you apply pressure to a throat or neck and there's any lack of oxygen, that is extreme manifesting extreme difference value from life, because they talked about the long-term and short-term consequences of just a littlest of pressure, the littlest. And they even like, we talk about the pressure to totally occlude someone's jugular vein is like less than a cap on a soda. So it was like all those examples of why this was written as it originally was, saying just proof strangulation, and you have this because of really the health consequences are so extreme. And I may not be getting your question right. I'm trying to see if
I think my
Annis may be able
question,
to
my
answer
question
better
may
too.
be more appropriate for 2012. And I think.
And I think
it's
Jen
where I'm
Annis
at.
was here in 2012 as part of it, and she probably could, if she understands your question, I apologize if I'm just,
No,
she
and
might be able to answer it.
It may
better.
be a question for not this work session.
Any further questions for Shira Burns? All right.
Thank
You for joining us.
Can I just review so that we're all on the same page?
Yes.
Okay. So if you have the PowerPoint, which unfortunately doesn't have page numbers, but if you count to page 9, it's the proposed legislation. So what I believe the bill sponsor is now requesting that you do is to strike everything from her bill. The bill did include suffocation. It did raise it to a class A. It had training and a whole bunch of other things. And instead replace all of those provisions of the bill with the proposal that you see in here from the Abuse Commission, which is to remove from paragraph C of the aggravated assault statute, strangulation. So right now it says circumstances manifesting extreme indifference to the value of life, which could be strangulation. Now you take that right out and you just say aggravated assault is strangulation. So if the person impedes the breathing or circulation of the blood by intentionally, knowingly, or recklessly applying pressure to another person's throat or neck, that in and of itself, no need to talk about manifest indifference or anything else. That in itself would be aggravated assault. It would stay a class B like it is currently. Then you would add newly suffocation. So if you intentionally, knowingly, or recklessly applied pressure on another person's chest or blocked their nose and mouth, and that impeded the breathing or circulation of blood, then that would also be aggravated assault, class B crime. What you don't see here are the mirror amendments to the domestic violence aggravated assault statute, which doesn't change the class of the crime. It just allows people to know that that crime was committed against a family or household member or dating partner. I assume for data collection purposes, it's the same level of crime, the same elements, you just add in the relationship to the victim. So that's the proposal before you, and 3 and 4 were before you, but smushed into paragraph C when you last considered this bill and had a work session with all the stakeholders here. I just want you all to know what's being proposed. I'm not suggesting you need to vote it today. I think people were confused about what was being proposed, and I felt bad about that.
Thank you for clarifying that. Representative O'Halloran.
Thank you. Did I understand you to say it's taking out the training?
Yes, everything else that was in the original bill would not be in the bill. What I understood the Abuse Commission to say is that their statutory mandate already allows them to make recommendations to the executive branch and the judicial branch, and they are going to recommend the training through their statutory
I just
power
wanted
to
to make
recommend
sure.
it.
Okay, I just want to make sure there would be training.
Well, I can't guarantee there will be, but they're going to be recommending to the executive and judicial branch that there is.
Thank you.
Representative Sato.
Thank you, Madam Chair. I just want to ask about the CJPS review, about whether we'd be creating a new crime, no new crimes, 2 new crimes.
I think you're creating at least 1 new crime. Possibly 2, I think out of an abundance of caution, understanding that the purpose of that review is to really make sure there's another eye when you define the way crimes are being done. I think it makes sense to ask them to review it. They may say, when they look at it, well, these are already kind of already included, so we don't think there's a big impact. But I think the spirit of the rule is to have them review this.
Thank you for that reminder. Committee members, so now that we have the amendment so carefully articulated, do committee members feel that we can move forward with a motion and a vote today? Or do you folks want another work session with another opportunity for input? Today was noticed as a work session, but if people don't have the information they need, we can hold another one. Senator Hagan?
I'm just one guy, don't mind not getting my way, but I would prefer another work session so I can continue to go through that, but a lot of my questions have been answered, so.
Okay.
But if that's not the feel of the committee, it's not a problem.
Janet?
If that's the feel of the committee, which I know you're only one person, but if it is, you do have a slate of work sessions on Friday afternoon. And I'm free Friday morning, so I could try and put the language together. I think between now and then it wouldn't happen, but you could try and do it then. And I could, if you want, email this abuse commission report directly to the MACDO president and ask them to weigh in on that legislative proposal if that helps.
Thank you. I was gonna ask if you had time to do that. Representative Henderson?
Thank you, Madam Chair. Two questions. First for Janet. Do you sleep? Or no, okay, fair. And the second one, I mean, it seems, I don't know if that's the direction the committee is going. I'd like to hear from MACDO, but I think if we are to move forward, the committee decides to vote today. I would like to caucus before we do so.
Okay. Other members, Representative Sato?
Thank you. I think I would prefer to wait and hear from Actel.
Okay. Yeah, are there any other entities that committee members would like to hear from so that we can engage them now and not have any further delay in case we're able to meet the deadline on Friday? Representative Sato?
PDS.
Okay. We can ask them to weigh in. Any other organizations or entities? Okay, so it sounds like we're going to close the work session for today and oh yeah, we do need to move to table. Thank you, Representative Anderson. Can I recognize you for a tabling motion?
Thank you, Madam Chair. I move we table this item.
Thank you. And a second from Representative Poirier, all in favor? Okay, and that's unanimous of everyone present. And I'll close the work session and then we'll follow up about feasible timing later in the week.
And we do have one more item. This is a revised memo to AFA to see if you want to vote for it.
I think. All right, so we are having a committee discussion on LD 549, which is currently on the appropriations table.
So I can remind you of what's going on. Just in brief, you dealt with the Safe Kit bills last year, voted out two bills that both incorporated mandatory tracking and an inventory of all of the safe kits that have been used in the state so far. The bill before you, LD 549, also included mandatory testing of any kit completed after a certain future date so that the person who the kit is being performed on knows that that mandatory testing applies if they report the crime. So that's why you picked the future date. There were two committee views on that on LD 549. The majority report was If you've warned the victim so that they know there's going to be mandatory testing if they report the offense and it's completed after that date, then the testing has to happen. There were 3 members of the committee who voted for everything, except they also wanted to give the victim a later chance to opt out if they later decided that they don't want the kit to be tested. After several discussions with different stakeholders this year, there was a suggestion that maybe the committee might want to unanimously request to not have that opt-out because the opt-out is the version of the bill that's on the appropriations table right now. And last time we had a draft language because you thought it would be easier if you looked at draft language to see if you agreed with it. And last time we had draft language, the memo before you today matches that exactly except for bullet point number 2 on the back page, which has been highlighted for you. So I tried to guess what the reasons were, and I guessed slightly wrong. So originally, this bullet point talked about whether allowing victims to revoke consent would somehow have an interaction with whether defendants exert undue pressure on them to revoke their consent. And folks on the committee didn't like talking about that. And instead, the representative from NICASA explained that there are major practical problems with allowing a later opt-out. And because of those practical problems, you may in fact be making a promise to victims that in statute that you cannot keep, including the fact that if they make their request to not have it tested while it's being tested, it's really hard to stop it. And also a judge may order that the kit be tested, for example, because of the constitutional implications. If the defendant says, I don't disagree that something happened to that victim, but it wasn't me, and I want that kit tested because it's not going to be my DNA. So the prosecution has evidence of a reported crime, and that evidence might be exculpatory. Under the Constitution, they may be required, especially if the court orders, that that be tested. So those practical reasons were what you instead wanted to emphasize here, and you directed me to work with Mikasa, Carrie Capaldo in the back, who I'm saying the wrong name, Carly Fisher in the back, and she did help me. And this is the language I came up with that she signed off on. So if you don't like it, it's my fault, not hers.
All right, thank you for that reminder. Committee members, are there any questions on the rewrite? And does it comport with everyone's intentions? Clarification, I'm seeing some thumbs up. Great. Any concerns? This is almost like a language review, but on a letter instead. All right. Do we need
It's
to do a
also,
straw vote or anything, or we can just?
So you never actually
consensus?
voted. You didn't want to vote until you saw the letter. So, well, memo, letter, whatever you want to call it. So we don't have everyone here, but my understanding was because this was a divided report and the minority report is what's on the table, that folks sort of seemed to reach a consensus that unless there was unanimity on the committee, you didn't want to send this memo. We don't have everyone here, but we can get late votes. I would suggest you vote on it and see if you have enough votes that you feel comfortable with me sending this letter over to AFA or not.
All right, and since we're seeking unanimity, I suppose we can do a roll call. Representative Sinclair, did you have a question?
I do have a question. Thank you, Madam Chair. It's a procedural question. The version that actually passed both chambers was the original minority report of this committee. Where are we procedurally if this committee, subsequent to all of that action, sends a letter to AFA just saying, hey, could we please change this? What then happens with that suggestedly amended chunk of legislation? Does AFA on their own just say, okay, we'll scribble out that part and call it goodsies, or does it then have to pass each of the two chambers
So
again?
even if AFA likes the opt-out language that's in there, they have to propose an amendment to the bill on the table because some of the dates in the version that's before them probably won't work anymore. And they might have updated, I'm sure they'll have updated fiscal information. So anytime something on the table is amended in any way, it has to go back to the House and the Senate to see if they vote to enact it. And even, I think even before you get to the vote to enact, you have to back it up and take the old amendment off and put the new amendment on and all these procedural steps I'm not an expert on. That must be really exciting for you.
It'll be at about 2 a.m, so it'll wake us up. All right, did that answer your question?
It did.
Okay, great. So is there anyone who'd like to make a motion? Representative Lee?
I move that we approve this letter to be sent from a unanimous committee to AFA.
Thank you. Is there a second? Thank you, Representative Pugh. All right, any further discussion? I think we're ready for a vote.
I can keep track of it. If you just yell their names out, that works for me.
Okay, I'm happy to do that. Madam
Sorry,
Chair,
not you.
Senator Carney, Representative Kuhn,
Yes.
Representative Kuhn votes yes. Senator Hagan,
Yes, yes,
Senator Hagan votes yes. Representative Poirier,
Yes.
Representative Poirier votes yes. Representative Sinclair,
Yes.
Representative Sinclair votes yes. Representative Pugh.
Yes.
Representative Pugh votes yes. Representative Henderson.
Yes.
Representative Henderson votes yes. Representative O'Halloran.
Yes.
Representative O'Halloran votes yes. Senator Talbot Ross. Representative Lee.
Yes.
Representative Lee votes yes. Representative Sato.
Yes.
Representative Sato votes yes. Representative Babin.
Yes.
Representative Babin votes yes. Representative Caruso.
Yes.
Representative Caruso votes yes. Representative Dana. I'll recall the absentees. Senator Carney. Senator Carney is absent. Senator Talbot Ross. Senator Talbot Ross is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 11 members voting in the affirmative, 0 in the negative, 3 members are absent, and that is the vote of the committee.
All right, thank you. So that's unanimous so far. We'll collect those final votes.
Yes, and at least one of the people not here did support that minority report, which is what's on the table. So I don't know how we would proceed with that, but I'm open to suggestions.
Okay.
I don't know, do we need them to vote on mic? Is it enough if I reach out and ask and then sort of report back orally on mic?
That would
at
be
some
great.
point?
Thank
Okay.
you for doing that. I think that's our last item for today, unless Janet, do you need anything else from us? All right, motion to adjourn? Second? All in favor?